Tomorrow, Wednesday, October 15th, 2014, the Supreme Court will hear oral arguments in a patent case captioned Teva Pharmaceuticals versus Sandoz. The patent in that case relates to Copaxone, which is a drug related to treating MS that has multi-billion dollars in annual revenue. And the issue in that case has to do with what is the proper standard of review that the appellate court should use to review claim constructions of a patent done by trial courts. It's important to understand that first, patents, every issued patent has at least one patent claim, and what that claim is it's a description in English of what the boundaries of the patentee's exclusive rights are. And then second, in patent litigation, there's almost always a dispute, and the dispute is really important to the resolution of the case, about what the meaning of those words are. And that process is called claim construction. The court eventually has to decide what the claims mean. And so in 1996, the Supreme Court decided, in a case called Markman versus Westview Instruments, that that process of claim construction was done by a court and not by a jury. And so in this case, the words are molecular weight, that there was a dispute about. The trial court wanted to understand what a person having ordinary skill in the art would understand the terms molecular weight to mean as of the time of the patent, which were much earlier than the time of the lawsuit. The court eventually decided that it meant peak molecular weight, and then that issue got appealed up to the Federal Circuit. Now, the existing law, which is what the Federal Circuit applied, is that a Court of Appeals for the Federal Circuit, which hears all patent cases and patent appeals, that they review the district court's claim construction de novo. They review it fresh. Okay, they don't give any deference. And Sandoz has argued that that rule of no deference should be gotten rid of. Teva argues that trying to figure out what a person of ordinary skill in the art understands a term to mean at a different time is a fact question, and fact questions are things that we give deference to the lower courts on. Sandoz, in contrast, argues that first, the Supreme Court has already decided that claim construction is an issue of law, and questions of law we do not give any deference to. And second, that there's considerations that patent law needs to be uniform. And by that, what Sandoz argues is the same patent has to be construed the same in all the district courts. And if we have different standards of review, it's possible that there would be different claim constructions that could be affirmed in different places in the country. It is possible that the Supreme Court, when deciding this case, decides to adopt a kind of middling approach where some aspects of claim construction are reviewed de novo, while other aspects are given, the trial court's claim construction is given some deference. So this case is important both because because claim construction is a critical issue in patent litigation, and this also affects the boundaries and the kind of relative power of trial courts and appellate courts. If the Federal Circuit reviews things de novo, then they have really the final say and the ability to just construe claims as they think is proper. While if trial courts are given substantial deference on their findings, then the trial court's findings are more likely to be the last word.